Well, hello, COS supporters. Welcome back to a special edition of COS Live. My name is Andrew Luce. I'll be your host. And of course, I'm joined by my co-host, Rita Peters, who's also the Senior Vice President for Legislative Affairs. Rita, it seems like it's been a long time since we were covering a committee hearing, but it's only been like a week or so. How are you doing today?
I'm doing great, and I'm happy to be back with you, Andrew, for today's hearing. It does seem like it has been a while. Things were so fast and furious there for a few weeks. It seems like we hardly got a break, but now we've had a little bit of a break and we're ready to go again.
Yes, it was a nice reprieve, caught our breath. And it was also a nice reprieve for Deanna Beckett as well, regional director out west. She had just so many hearings and so much floor action the last several weeks. Today we're moving to a different place. We're moving to Ohio. In a few moments, we are expecting public hearing hosted by the Ohio Senate Committee on General Government in consideration of our Article 5 Convention of States legislation. Rita, our viewers are going to hear it referred as SJR3. So just to get our viewers caught up, 19 states have passed the Convention of States resolution so far, and it's calling for a convention on three topics: fiscal restraints, term limits, and reining in the power and scope of the federal government. So, Rita, we need 34 states to call a convention. That's the magic number. So just 15 more to go, and then we can have the first ever state-led convention to propose amendments to rein in Washington, D.C. Additionally, there are 20 states that have introduced our resolution in 2025, and of course, Ohio is one of them. So, Rita, can you get our viewers caught up on how we got to this point in Ohio?
Yeah, well, Andrew, the Convention of States Ohio activist team has been busy building support across their state for Convention of States. More than 117,000 Ohio citizen activists have signed the petition asking their legislators to vote yes for COS. And according to a study by the Trafalgar Group, almost 2/3 of Ohio voters, that's 62% of Ohio voters across party lines, favor the state calling for an Article 5 convention to propose constitutional amendments on our three topics: imposing fiscal restraints, limiting federal power and jurisdiction, and setting term limits for federal officials, which of course includes members of Congress, but could also include federal bureaucrats or even federal judges. Now, to give you a little bit of context about what you're going to see today, on February 16th, Ohio had its first sponsor-only hearing on our Article 5 application, which, as you pointed out, is SJR3 in Ohio. And so this is the way Ohio does things with committee hearings. It's a little bit different. It's the only state that does it this way. They have a series of hearings on every bill and resolution. So typically the first one is where the sponsor just presents the legislation, explains to the committee members why he or she is offering it, what it's about, goes through it, answers questions if the committee members have questions. So that part has already been done for our Convention of States application, SJR3. Again, our sponsor, Senator Michelle Reynolds. So today is the second step in the hearing process. This hearing will be for proponent testimony only. So you won't hear opponents today. Usually they're all in the same committee hearing. All the members of the public come on one day and give testimony. Ohio is different in this regard. So today is the day for proponent testimony. You are going to hear Senator Rick Santorum. He is on the ground there in the Capitol and set to give expert testimony on our application. And then I know at least 6 of our Ohio grassroots team are planning to give their testimony. And I've got to tell you, that team is organized. They have it all laid out as to which order they're going to go up in, what topic each of them is going to cover in their testimony. I expect you to be dazzled and impressed by what you see of that Ohio team today. And then the other thing I want to let you know is Our 34 Ready legislation is also being offered at the same committee hearing. We were the only two items on the agenda today, and that's SB 112. So you'll also hear that introduced and just the sponsor introducing it, explaining what it's about. And for those of you who aren't familiar with the term, 34 Ready is the legislation that basically outlines the procedures that Ohio will use to choose, instruct, and oversee its commissioners once an Article 5 convention is called. So they don't have to have that piece in place before they pass our COS application, but they do need to eventually get it in place to be prepared once the first Article 5 convention is called. So you'll hear that just be introduced today. And then I think we're going to hear proponent testimony on that as well today. So those are the only two things in the hearing, which makes it nice for us, Andrew, because we don't have to sit and wait and wonder how long they're going to be on a bunch of other bills before they get to us, right? So
Right.
let's hope that they start on time.
Yeah, so they start on time. And also, I'm just so thankful that we get to hear proponent testimony, because I don't know if my ears could handle the opponent testimony today, or my stomach for that matter.
Right.
While we wait, we also have some national updates to roll through, because we're going to be starting in just a couple of minutes. I know we're going to be, I'll let you there. We have some action coming up tomorrow. Can we talk about that for just a few moments?
Absolutely. So tomorrow's going to be a really big day. We're expecting the Idaho House of Representatives to debate and vote on our COS application there. That's a big deal. We have not had a floor debate and vote in the Idaho House before. So this will be a history-making event. You'll want to tune in for that tomorrow. We think it's going to be sometime between 1 o'clock and 2 o'clock p.m. Eastern time. But again, it's hard to predict with their floor calendars. You don't know exactly how long it's going to take for them to get through different things. But Andrew, you and I will be here to provide coverage of that, let folks know what they can expect. And I'm sure producer G will have some of his amazing videos ready to go in case we do need to stall a little bit and they take longer than expected. And Andrew, I want to mention too that we've had 3 chamber victories already this year. Both the South Dakota Senate and the Wyoming Senate have passed our resolution. Now, unfortunately, we went on to see a defeat in the houses of both South Dakota and Wyoming, narrow defeat. But we were excited to get to those floor votes. And what that does for us, Andrew, is it lets us know exactly who we need to convince, which legislators are not quite there yet, which ones need more education, more training on Article 5, which ones need more grassroots outreach. And so, the work kind of begins again after we get those floor votes. And even though technically it was a defeat and that we didn't pass the application in those states this year, it really just provides our teams with vital information that they need in order to carry the application to the finish line the next year. So that's exactly what we're working on doing in South Dakota and Wyoming. Our teams don't rest. They don't just go away when legislative season ends. They start planning and executing their plans for working throughout the interim season up until the next session. Now, we are still awaiting action by the New Hampshire House and the Iowa House after seeing victories in committees in both of those bodies. I should also mention we also passed the Kansas Senate by a super majority this year. The vote was 29-11. What an incredible achievement for our Kansas team. And now our application is pending on the House side. We're looking for a committee hearing, not this week, but probably next week. So stay tuned for more details on that. That should be another exciting committee hearing for us to stream. And Yeah, as you mentioned, Andrew, a total of 20 states have filed our Article 5 application this year. And just to run you through that list, we've got Connecticut, Hawaii, Idaho, Illinois, Iowa, Kansas, Kentucky, Massachusetts, Minnesota, Montana, Nevada, New Hampshire, New Jersey, Ohio, Rhode Island, South Dakota, Texas, Vermont, Washington, and Wyoming. And as you also mentioned, 19 states have already completely passed our COS application. I don't know if producer G has that graphic handy. He has such a good one that
We need
shows.
that graphic. That's for sure.
Yeah. Yeah. Oh, here we
Oh, it
go.
looks like they're
Let's
going
take
to the
the
committee.
hearing.
On the Senate floor, we start by honoring God and country. So if you'd bow your heads with me. Heavenly Father, Lord Jesus, we just lift today up to you today. Father, you are amazing. Lord, we give you all honor and glory and praise. Lord, thank you for your mercies that are new every morning. Lord, I ask a blessing upon all the committee members here today, those that are also gathered here in the audience. Lord, that you protect them, protect their families. Lord, and I ask for wisdom and discernment, Father, as we deliberate all these matters that have been placed before us today. Thank you. And it's in your Son's name, Jesus, that I pray. Amen. Please rise. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. All right. Thank you. And with that, would the clerk please call the roll?
Chair Rogner.
Here.
Vice Chair Gaveron.
Here.
Senator Huffman. Senator Reineke. Senator Timken.
Here.
Ranking Member Blackshear.
Here.
Okay.
Senator DeMora. Here.
All right. Quorum present, would the members please take a minute to look at the minutes from the previous meeting? That's March 4th. You'll find those on your iPads. Are there any additions, subtractions, or changes to the minutes? Seeing none, the question is, shall the minutes be agreed to? And without objection, the minutes are agreed to. All right. First, I again would like to just welcome everybody here today that's in the audience. Those of you tuning in online, welcome. We're glad you're watching. Our first order of business is a first hearing of Senate Bill 112 to establish appointment procedures for a constitutional convention sponsored by Senators Reynolds and Lang. This bill was indicated to receive sponsor and proponent testimony today, so I'll start by calling up Senator Reynolds to provide sponsor testimony. Welcome to committee, Senator Reynolds.
Thank you. Thank you. Good afternoon. Chairwoman Rogner, Vice Chair Gavarone, Ranking Member Blackshear Jr., and members of the General Government Committee. Thank you for the opportunity to provide sponsor testimony on Senate Bill 112. This bill serves as a second part of our Convention of States legislation. Following the passage of Senate Joint Resolution 3, SJR 3, while SJR 3 urges Congress to call for a convention of states under Article 5 of the U.S. Constitution, Senate Bill 112 establishes the procedures for how Ohio will select, instruct, and oversee its commissioners to such a convention. Under Article 5, Congress is required to count state applications for a convention to propose amendments and to formally call the convention once 34 legislatures agree to the topic or topics for amendment proposals. So that's 2/3 of the states. As of today, 19 states have applied for an Article 5 amending convention under the Convention of States application. In the 2025 legislative session, 21 additional states have filed the same application. There are also other Article 5 efforts underway. So as momentum grows for an Article 5 amending convention, preparing commissioner legislation to be ready for the 34th state to apply for a convention is becoming more urgent, hence the need for Senate Bill 112. 14 states have already passed similar legislation, and in 2025, 25 states have introduced new commissioner legislation or updates to their existing legislation. Historical precedent confirms that at an interstate convention, the state legislature chooses commissions to oversee agents to represent its interests. The Supreme Court decision in Chiafalo versus Washington underscores that authority, but it is up to us to determine the specific process. So this legislation addresses several key details. Number one, selection. Delegates shall be appointed by a concurrent resolution of the General Assembly or by majority of those present and voting in a joint session of the General Assembly. An odd number of delegates will be appointed to represent Ohio. Number two, qualifications. Must be a U.S. citizen for at least 5 years, must be a resident of Ohio for at least 5 years, must be at least 25 years old, must be a registered elector in Ohio. Prohibited from serving would be federal lobbyists within the last 5 years, federal employees or contractors within the last 10 years, excluding members of the armed forces, federal elected or appointed officials within the last 10 years, individuals with felony convictions involving moral turpitude or any felony within the last 10 years, statewide office holders while serving as a delegate. Number three, oversight. An advisory committee consisting of one member of the Senate appointed by the Senate President, one member of the House of Representatives appointed by the Speaker, one member of the General Assembly appointed jointly by the Senate President and the Speaker, approved by a majority in each chamber. A delegate may be recalled at any time and for any reason by a concurrent resolution of the General Assembly or by the advisory committee if the General Assembly is not in session. And a vacancy may be filled in the same manner as the original appointment. Number four, instructions. Commissioners shall not alter the one state, one rule vote. Commissioners shall not alter any existing individual right guaranteed in the U.S. Constitution, and instructions may be modified by the General Assembly at any time. Number five, ethics and conduct. Delegates are prohibited from accepting gifts or benefits exceeding $200, excluding gifts from immediate family members. Delegates are prohibited from promoting any changes to the one state, one vote rule or any amendment altering individual liberties established in the Constitution. And delegates must avoid giving the impression that the delegation is divided on issues where formal position has been established. And lastly, number six, penalties. It establishes a third-degree felony for commissioners who violate their instructions, and it establishes a third-degree felony for anyone who bribes, threatens, intimidates, or obstructs a commissioner in the performance of their duties. SB 112 is a critical next step to ensure that Ohio is prepared to participate effectively in a future Article 5 amending convention. This legislation ensures that our state delegation will be well-structured, accountable, and ready to represent the best interests of Ohioans. Thank you for your time and consideration. I'm happy to answer any questions at this time.
Thank you, Senator Reynolds, for bringing this bill forward. Senator DeMora.
Thank you, Madam Chair. Senator Reynolds, so me being the, I guess, the pain in the butt here, I looked at all the qualifications. So say Ohio had 51 people we were appointing to this body. All 51 of them, what I read, could all be straight white men. There's nothing here for diversity. There's nothing here for men and women. There's nothing here to represent different parts of the state. We could theoretically have 51 people that come from Columbus, Ohio that are straight white men. Is there any guideline? Am I wrong in that interpretation that this could not happen that way?
To the chair, to the senator, in the same way that there's nothing in here that ensures that it wouldn't be straight white men, there's nothing in here that precludes it either.
So, well, I understand it doesn't preclude it, but I mean, again, there's nothing that says that our delegation to this potential convention has to look like the state of Ohio. So, I mean, why wouldn't we want a delegation that looks like our state? Why would we want, why would we not have that in this, to have X people coming from, X number of people from different parts of the state, or X number of men and women? I mean, no offense, when my party does anything, we have to have equal amounts of men and women within one, and our delegation to any event has to look like the proportionality of the state as a whole. So, we have to have X number of people of color, X number of people of so if we're representing the state of Ohio, why wouldn't we have that built into this bill to state that it has to look like the state of Ohio as a whole?
To the chair, to the senator. So I appreciate your comments. But if it is the will of the legislature to determine who is going to go, as long as they are meeting these qualifications, I don't necessarily know what color they have to be able to do that. So as long as the qualifications are met and the legislature and whoever's in charge is appointing those individuals, I don't necessarily know that it matters what color that person is.
Thank you. Are there any additional questions? All right, seeing none, thank you for your testimony today and for bringing this bill forward. All right, now I'm going to call up those offering in-person proponent testimony, starting with U.S. Senator Rick Santorum from the Convention of States Action. Welcome to committee, Senator.
Thank you very much, Madam Chair and members of the committee. It's an honor to be here. It's always a little nerve-wracking for a Penn State grad to be in Columbus to present any kind of testimony, but I'm sure you will be kind to me, certainly hopefully kinder than your football team is to mine on an annual basis. It's an honor to be here, as I mentioned. I'll be brief. This piece of legislation is important for a couple of reasons. Number one, there's a lot of folks who contend that Article 5 of the Constitution is unclear about a lot of things, and therefore there's a lot of things that are said that may or may not be true. In fact, I don't think they are true, but this would be a piece of legislation that would clarify very important things. The most important thing is, and it's sort of logical and it's obvious, but to some people it's not, is that the Constitutional Convention in 1787 provided two ways to amend the Constitution, and they wanted one way for the Congress to control and one way for the state legislature to control. There are some who suggest that the Congress can control both, which of course wouldn't make any sense that the Constitutional Convention would propose two different ways of amending the Constitution if Congress would control them both. But this clarifies to anybody here in Ohio that in fact, Ohio and the state legislature controls who in fact attends this convention and all of the decisions that are made at that convention. This also, I think, reaffirms what the founders intended, which is that this would be a process that would be limited, that a process that states would have to agree on what the subject matter of the convention is about, and all 34 states having identical, if similar to identical language. So the parameters of the convention would be known, and that the state could bind their delegates to limit their activities to just those things that are the subject matter of the call for the convention. So it's important, just for a clarification, whether it's the Convention of States resolution that we're going to be talking about next, or any others, and there are many others that are being contemplated right now, it's important for the states to assert themselves as to how they would like this convention to be operated and how they want their delegates to perform. Thank you, Madam Chair.
All right, thank you for your testimony. Are there any questions? Actually, I do have one, and I understand you are coming back for SJR 3 here in a moment as a proponent as well. But this particular bill, the Senate Bill 112, has to do more with almost like who we are going to appoint, the requirements. And my understanding is it can be different by state. It's determined by the legislature. Right. So from your experience, you have more of a national picture of this. Do you see these requirements that Senator Reynolds just laid out that are in this bill? Are those the right ones?
I hesitate to say which are the right ones because lots of states do it differently. For example, I just came from Wyoming, and Wyoming several years ago passed a statute that limits it to 7 people. They actually call out the exact number. Okay. Other states have a different number. Some have criminal penalties, like you've suggested. Indiana, your neighbor Indiana, for example, has criminal penalties, felony penalties. Other states don't have any criminal penalties at all. So it really is up to the states to determine, how much you want to bind your delegates with respect to having that sort of Damocles hanging over their head. But again, once you appoint your delegates, that's another opportunity for the legislature to have a say as to how they want their delegates, or commissioners, they're called, commissioners, to transact at the convention.
Thank you. Yeah, I just thought with your perspective over the entire nation and visiting these different states, if you thought there were some best practices that we should make sure we consider.
It depends how much you want it buttoned down. This is buttoned down.
Okay.
This is a very, there are a lot of people say, oh, we don't, we'll send delegates to the convention and they'll go crazy and they'll do all sorts of things. Candidly, I don't foresee that happening. I'm not the least bit concerned about that. I think if you are sent to a convention, the first in the history of our country, to do something to try to bind the wounds of the country, to try to find some consensus, you're not going to go down there and go crazy. You're going to take the responsibility that comes with the appointment and use it to try to do something to help the country. But some people don't feel that way, and they're suspicious, and therefore you have folks who have put provisions like this in to make sure it doesn't happen, to put penalties on there. Some states say yes, some states say no. Again, it's how buttoned down do you want to be?
Very good. Thank you. Are there any additional questions? Senator Demora.
Thank you, Madam Chair. This is going to be a follow-up to the Chairwoman's question, since you are speaking about other states, and I don't, and I don't think anybody else here does. So ours pays people to go and gives them expenses. I mean, are other states paying? Is it, for instance, are people from Ohio who are getting paid? Are other states who maybe not getting paid or not getting expenses going to be jealous of that? I don't know how many states are paying that sort of stuff.
I don't know of every single one, so I don't know. I do know that many states do pay, because it's anticipated, don't know, but it's anticipated that the person would be going there for a period of weeks, if not months, to go through all of the hearings and testimony and writing and et cetera that takes place. And it would be a full-time, vocation during that period of time. And so they do provide some sort of stipend usually. And of course, the state would be required to sort of pitch in to help cover the cost of the convention overall. So there would be expenses from the state to conduct this convention.
Very good. Thank you. Any additional questions? Senator Blackshear.
Thank you, Madam Chair, and thank you, Senator, for your testimony. Just two quick questions. From what you've seen from other states, is there a partisan requirement from other states, or is it like how this bill is, where the Speaker and the Senate President are able to appoint somebody?
Yeah, most of them I've seen are just allow for the Speaker and the President or President Pro Tem to make selections, and those selections are then voted on by the body.
Do you
follow up?
Thank you, Madam Chair. But do you feel like that's a true reflection of that state, with it being primarily, honestly, one party?
Again, that would be up to the Speaker and the leader of the Senate to determine what the political makeup would be. I would assume some states would have bipartisan with maybe reflecting the majorities. Some might not. Some may be of just one party. But that, again, is something that would be voted on by the body.
Very good. Thank you. Any additional questions? All right. Thank you very much. Thank you, Senator Santorum, and we're going to have you back up here in just a moment. I would like to call Vicki Garassi to come forward. And while she's coming up, if everyone could just take their cell phones out and silence them, please, that would appreciate it. Thank you. Welcome to committee. You may begin whenever you're ready.
Thank you. Good afternoon, Chair Rogner, Vice Chair Gavarone, Ranking Member Blackshear, and members of the committee. My name is Vicki Geraci. I live in Columbus, Senate District 19, where more than 3,500 citizens have signed a petition asking for an Article 5 convention to propose amendments as outlined in SJR 3. Thank you for the opportunity to speak on SB 112, companion legislation to SJR 3. As a mother of 7 and grandmother of 10, My family will be responsible for the payments on the debt due to financial waste, fraud, and abuse created by our unchecked federal government. We have witnessed financial mismanagement every day since DOGE was implemented. In the past 5 years, there has been a 2% increase in population and a 53% increase in spending. People are fed up. As state legislators, you have been given power through the Constitution to limit our federal government and strengthen the states by restoring federalism. We are asking you to embrace this responsibility. Recent polls of Ohioans are clear. You have nonpartisan support for Article 5. The question that inevitably follows are the what ifs. What about runaways, opening the Constitution, and so on? The reality is that SJR 3 merely supports a call by states to participate in a discussion on 3 limited topics for the purpose of proposing amendments. Everything that results from a convention will be returned to you for ratification. You will determine the final product. But what about the rogue delegate who suggests topics outside of the bounds of the 3 topics proposed in SJR 3? Term limits, fiscal restraint, and limiting the size and power of the federal government. Thankfully, Ohio has proposed SB 112 to ease any concern about delegate selection and expectations. It is a companion bill designed to restrain delegates from exceeding their call and has application with any Article 5 resolution during the convention process. As citizens, we have exhausted all other means to rein in the federal government. We knew our tax dollars were being wasted. However, DOGE has confirmed the truth. Citizens are shocked and outraged to learn just how poorly our tax dollars are being managed by both elected representatives and unelected bureaucracies. Article 5 is our last remaining peaceful solution to address our severely bloated federal government and its excessive, unconstitutional bureaucracies. Unfortunately, DOGE can only reveal and recommend. It lacks the necessary permanence of constitutional amendments. We need the comprehensive solution proposed in SJR 3 combined with the protections and penalties found in SB 112 to safely put this genie back into its bottle. An historical convention of states will happen. 14 states have already passed similar delegate selection legislation to SB 112, and 20 states have introduced legislation or updates to existing legislation. Ohio must be prepared to participate. We owe it to future generations. Please support SB 112.
Very good. Thank you for your testimony. Are there any questions for this witness? All right, seeing none, thank you for being here this afternoon.
Thank you very
Our
much.
next witness is Steve Jones. Welcome to committee, Mr. Jones.
Chair Rogner, Vice Chair Gavarone, Ranking Member Blackshear, and members of committee. My name is Steve Jones, and I'm from Senate District 7. I first signed a petition supporting Article 5 Convention of States back in the fall of 2013. 12 years later, I come before you seeking your support for SB 112. It is my joy, once again, to provide proponent testimony in Chair Rogner's committee, although this time it's in the Senate and not the House, and it's for SB 112. In 2019, my then representative and my senator both requested that I provide more information about delegate selection. They had their concerns about the process for selecting and directing delegates for an Article 5 state convention. So I studied COS is past states to see what had been written by the other states, and then from scratch drafted my own personal version based on what I had learned. I didn't do this one, and I'm very happy though that there are people smarter and wiser than me who drafted SB 112, and I support it. SB 112 provides procedures regarding the selection, introduction, and oversight of commissioners to any and all Article 5 amendment proposing convention efforts. It includes criminal penalties for any commissioner who violates their instructions. Frankly, this companion legislation could have been addressed by the Ohio legislature immediately after they passed the balanced budget amendment, Article 5 convention resolution back in 2013. This common sense bill is long overdue. First, I would like to note that SB 112 in lines 13 and 20, that the authority for the Article 5 convention is under Article 5 of the Constitution. In other words, the authority is under Article 5, not a bunch of states just willy-nilly doing what they want. The topics to be discussed must conform to the scope of the originating resolution and call of that convention. States like Ohio are only proposing amendments. Article 5 already outlines the ultimate methods of ratification to any amendment proposal. Second, all of the authority to select, authorize, discipline, recall, and replace commission delegates resides within the General Assembly, 11 times it's stated, or in the advisory committee. Congress will not be choosing nor controlling Ohio's delegates. The governor will also not be choosing or controlling Ohio delegates. We hope that you soon will be approving SJR 3, coming up next, to move to the floor for a vote. Your fellow senators and all Ohioans deserve the passage of SB 112 out of committee. The people want to know Ohio's legislative directive for choosing convention delegates and keeping them on the straight and narrow. I now ask you to support both SJR 3 and SB 112.
Very good. Thank you, Mr. Jones, for your testimony. Are there any questions for this witness? All right, seeing none, thank you for being here today.
Thank you.
And with no further witness slips received for this bill, this will conclude the first hearing of Senate Bill 112. Moving on to our second and final order of business, is the second hearing of Joint Resolution 3, sponsored by Senator Reynolds and Lang. This bill was indicated to receive proponent testimony, so I'll begin by calling up those proponents, starting again with our U.S. Senator Rick Santorum. And while he's coming up to the podium, I just want to compliment these three young men over there who've been so very well behaved. They're doing a great job. You guys are doing awesome. Thank you. Senator Santorum.
Thank you again, Madam Chair. And it's a pleasure to be back. You've heard this line from Ronald Reagan talking about I'm here from Washington. I'm from Washington. I'm here to help. I'm coming from Washington, and I'm asking for your help. I spent the last 35 years of my life. I got elected to Congress back in 1990. Served 16 years in Congress, ran for president a couple of times, and have commentated on things going on in Washington on all the major cable news networks for the last several years. And I will tell you with a matter of certainty that Washington is not going to fix the problems that it is confronting right now. I left the United States Senate, and I think that the national debt was between $6 and $7 trillion. It's $36 trillion. It's growing $1 trillion every 3 or 4 months. And nothing, you can talk about DOGE, but let's just be honest. President Trump isn't talking about cutting 80% of the budget is off limits. Can't touch it, according to him. Even if you cut the other 20, cut everything. We're still running a deficit. So the idea that things are going to fix itself in Washington. In addition, I will tell you, when I first came to this idea, I was not for it. I was a little concerned about how it would work. Never heard of this before. What's this Article 5 thing about? I'm sure many of you, when you first heard about it, felt the same way. And I was hesitant. And it really was watching the last 3 presidents that convinced me that not only was the economic train running out of control, which is going to lead to a fiscal collapse of the country at some point, but we have presidents who increasingly think, of both parties, that they can wave their pen and change the law at their whim. As a member of the Senate and Congress, even though I ran for president, I never believed that was the case, and I don't think it is the case. And the Constitution doesn't say they can do that, but they continually push. And they continually expand the power of the executive branch. This is a danger to the republic. How did this happen? It happened because this Constitution isn't the Constitution we live by anymore. This Constitution was changed. It was not just changed structurally, as I happen to believe the most important amendment change in the country, and I'm biased because I was a former senator, was the 17th Amendment. And the 17th Amendment, prior to that, you appointed United States senators. And as a result, you controlled what was going on in Washington, D.C. You gave that up 100 years ago. And look what happened from the time the Senate became popular elected to now. Prior to 1917, when they changed the rules of the Senate, prior to 1917, if you look at the size of the federal government, it was minuscule. At 1912, when the amendment actually passed, the only debt was about $150 from the Spanish-American War. There was no debt. Washington had nothing to do with the lives of the people here in Ohio, almost nothing. But that changed when senators had to get votes from the people. Prior to 1912, in order to pass a bill in the United States Senate, every senator had to agree to vote for it, to vote, not to vote for it, just to vote. Guess how many bills came up for a vote? Not many. The filibuster rule that was instituted back in 1917 was an amendment to allow things to get through the Senate. It only required 2/3 instead of 100%. In 1975, that was changed to 60%. And here's my concern. There's only been 3 times in the history of our history since 1917 where one party in the United States Senate has had a supermajority, a filibuster-proof majority. Only 3 times. It's hard to believe, but it's true. And all 3 times, it was the Democratic Party. And what happened during those times when there was no governor left on one-party control? What happened? The first time, the New Deal. The second time, the Great Society. And the third time, Obamacare. You allow for majoritarian control of the Senate. You have opened up the spigots of government power in Washington beyond anything that we've ever even contemplated. And why do I say that? Because if we don't do something now to start putting structural restraints on Washington, we are going to lose any kind of federalism that's left in this country. Senator Mitchell was at a convention that we had, a mock convention in Williamsburg representing Ohio. And out of that convention and every other previous mock convention, the Convention of States has held, one amendment has always come out. It's the only one that's come out of all 3. And that is limiting the Supreme Court to 9 members. That makes a lot of sense, particularly given the fact that one party has been very adamant, in fact, tried to do it last session, to change the filibuster rule to eliminate the 60-vote requirement and make it a simple majority. Now, I have a rare talent, and my talent is when people tell me they're going to do something, I believe them. And when the folks who are no longer in the majority get the majority back in the United States Senate and the presidency and the House, and they will, I tell you what they will do because this is what they say they will do. They will eliminate the filibuster. They will pack the court. And they will admit new states to the Union to make sure that the Senate is never controlled by Republicans again. They will change the voting laws of this country to make sure Ohio's laws are the same as every other law, every other state. And there will be federal control of elections. And that's just the beginning. This isn't a problem that's 10 years off. This isn't a potential fiscal calamity. This is maybe 2028. I hope I don't have to come back here in 2029 and say, I told you so. But this is the reality that we're facing. This is why I'm here. This is why I was in Cheyenne last week and Concord the week before, because I'm concerned, not in the future, I'm concerned about now. Ladies and gentlemen, whether it's the president's excess authority, whether it's the fiscal calamity, or whether it's what will happen to our country and the Congress if control is flipped, our house is on fire, and we have a bunch of people standing across the street looking at the house burning and saying, I may not want to cross because a car might come by and hit me. There's always a risk to anything you do in life. Crossing the street is a risk. But when you have the reality of what's facing this country, it is about time that you, the legislature, who are given the power, I've read, I can't even remember how many constitutional convention books I've read. Every one of them said the same thing. You were to be the final check. The states were supposed to be at the top of this food chain, and you were to make sure that our country was never got out of control. It is time for you to step up, and I hope you do so here in Ohio.
Very good. Senator Santorum, thank you again. Are there any questions? You referenced, this is an interesting topic because certainly I can see the reason to have this, but I would say conservatives are divided. I have also heard many conservatives say there's going to be a runaway convention, and you briefly touched on that, but can you talk a little bit more about why that's not a concern?
Obviously, the bill that you looked at earlier is part of the belt and suspenders.
Yeah.
But recall, this provision was written by the founders back in 1787. They knew all about conventions of states. 1787 convention was a convention of states. Every state got one vote, no matter how many delegates they had there. Prior to that was the Annapolis Convention. Prior to that, there were 20 or 30 other conventions. How the colonies operated before the Articles of Confederation was conventions of states. In the Constitution, there's a provision that says a trial by jury. Does anybody question what a jury trial is? Well, it's not defined in the Constitution. Does anybody say, oh, well, we don't know what a jury trial is? How do we know the Constitution? Well, because it was a well-known, understood thing at the time. It was part of how the government operated, just like how the courts operate. There was precedent galore on how state conventions operate, conventions of states operated. And so what do we know about those? What we know is that they're called for a specific purpose or for a general purpose. The Annapolis Convention failed in 1786 because it was called for a limited purpose, and the states there said it was not broad enough to deal with the problems confronting the Union. We had a convention of states not too long ago in this country called the Colorado River State Convention. It was to allocate water resources for the Colorado River, and the states involved with the Colorado River called for a convention by resolution. The states appointed commissioners. They went to the commission. They negotiated a settlement. They sent it out to the states for ratification. There was no question of a runaway convention that they were going to ban abortion in the states. No. Why? When you pass this, if you pass this resolution and you send it over to the House and they change 2 words, does it become law? No. You have to send it back because the language has to be exact. Same with any bill. Why? Because it is the language that governs the subject matter at hand. And if it's not the same, then you don't know what the law is. Same here. The reason that all 19 states have passed the exact same language is because Congress, up at this point in this country's history, has had 450 petitions for an Article 5 convention submitted to it. Have we had any convention of states? No. Well, wait a minute. We've had 49 states, 450 petitions. Why haven't we had a convention? Because 34 never passed the exact same language. If the language matters to call a convention, it matters at the convention. You can't say, well, you can't have a convention unless you all agree on what the subject matter of the convention is, and then get to convention and say, well, the subject matter doesn't matter. It's absurd. It's ad absurdum, as we'd say in the legal profession. In addition to that, people, again, the founders understood the hardest thing to do in this country is to ratify a constitutional amendment. There's no other body anywhere in America that requires 3/4 of anything to pass. Do you imagine, even in this body, which is fairly heavily controlled by one party, how many bills would you pass if you have to get 3/4 of the votes on anything? Not much. Now imagine trying to get 3/4 of the states to agree to anything. The idea that this would be a runaway convention is, again, absurd. There's no, if you look, and I'll be happy to start reading through the 27 amendments that have passed in our country, 17 since the founding. Does anybody disagree a president should serve 2 terms? Is anybody here for a poll tax? I mean, these are the amendments that we passed in this country. And we passed them, why? Because they were overwhelmingly popular. The only amendments that can get 3/4 of the states are amendments that have broad support, 80, 90% support among the American public. What runaway convention could produce something that's got 80, 98%? It's not going to happen. So there are, the founders put the ultimate restraints, 3/4, and remind you that you need 3/4 of both legislatures. And a legislature doesn't have to vote against it. You simply don't vote and you're not ratifying. The easiest thing for a legislator, I know, to do is not vote. And so this is hard. You have that, you have your delegate selection, and then you have the law that says that the convention is governed by what is the call of the convention. And you can't go beyond that call.
Excuse me, there are 19 states that have already passed this language exactly as it is
Correct.
presented. What is your, again, your big picture view from the other states, like the likelihood that we're going to get to where we need to be?
You know, we have probably 5 other states right now that are actively, I mean, they're introduced in almost every state. But as far as states that are, it's actively going through the process right now, I think we have 5 other states. We feel very, very good about North Carolina. We think we have an excellent, a very good chance in Kansas, and the same with Iowa. There's 2 other states, Montana and Idaho, that are also actively considering it at this point too.
Okay. And then final question I have is, and I think there's really no time limit for the states to pass the same resolution, or is it there? Okay, so it could happen over the next, I mean, obviously you want it to happen sooner than later, but if it happens in 2 years or 5 years, it could still happen.
That's correct.
You don't have to, okay.
There's only one state that has well, 2 states, excuse me, that have a sunset date. One is Texas, but they are in the process right now of actually eliminating that sunset clause and just putting it in perpetuity. And the other is Nebraska, and they're going through the same process too of extending it.
Very good, thank you. Any additional questions? No? Seeing none, thank you again for being here for both of these pieces of legislation. The next witness is William P. Scott. Welcome to committee.
Thank you. Good afternoon, Chair Rogner, Vice Chair Gavarone, Ranking Member Blackshear, and members of the committee. I'm Bill Scott from Dayton, Ohio, and Senator Blackshear's Senate District 6. Hello again, Senator. I'm also a volunteer with Convention of States, and I also serve as the state director in Ohio. Convention of States Resolution SGR 3 is designed to address 3 topics: fiscal restraints, term limits on Congress and federal officials, and limiting the power, scope, and jurisdiction of the federal government. Some ask, well, why have 3 areas to debate at this convention? Why not just one? Well, imagine you're a homeowner and you have a massive plumbing leak. You call a plumber, and he comes out to look at the issue. Does he arrive just with his trusty old pipe wrench to fix your leak? No. He brings his trusty toolbox with a whole bunch of things that's going to fix the leak. And, you know, similarly, our federal government faces a structural problem in how it conducts its business. The federal patient is in critical condition, so calling an Article 5 convention to focus on just one topic may not save the patient. That's why convention delegates need the flexibility to debate proposals responsive to all 3 of the previously mentioned limited topic areas in one whole of government approach to fixing problems. The fiscal restraints topic is what I'll talk about a little bit more today, because most people understand the issue and also suffer the effects of excessive government spending of theirs and their future generations, taxpayer dollars being spent without regard to the dire consequences of the deficits and the crushing national debt. Consider the trend of the federal spending over the last 5 fiscal years, 2019 through 2024. 2019 federal revenues were $3.5 trillion, that's T with a trillion, and expenditures were greater than that at $4.4 trillion, leaving a deficit of about 0.9 or $1 trillion back in 2019. Then what happened? COVID hit. And over the next 2 fiscal years, annual spending increased by over $2.5 trillion, leading to ballooning deficits of around $3 trillion in those years. In the fiscal year that just ended, September 30th, 2024, increased spending still approached nearly $7 trillion, and the deficit was still twice the level of 2019 at $1.8 trillion. Why is that level of deficit spending still happening years after COVID is over? That's a pretty logical question, and people ask it all the time. Well, I think it's because Congress is not doing their job and doing the required separate appropriation budgets to justify program spending, and rather just let the past spending be the starting point for new appropriations. Instead, we get CRs or continuing resolutions that are adopted to keep spending without accountability. And that's just unacceptable and totally unsustainable. They just keep kicking the can down the road to our kids and our grandkids. And that's just not right. I think you'll agree with me, or many will agree, Washington is addicted to spending, and they're spending other people's money. That's why in Article 5, intervention is needed by the states. Congress can't and won't do it themselves. But you, as state legislators with the powers granted in Article 5, can put some guardrails on Washington spending by calling for a convention to propose a common sense balanced budget amendment that would control spending along with some other topics available in the COS toolbox. Consider what your fellow state legislators from all over the country proposed at a fiscal restraint amendment in 2023 at a simulated convention in Williamsburg, Virginia. In summary, they propose that federal expenditures for each fiscal year shall not exceed the average annual revenue collected in the prior 3 fiscal years. And total expenditures, by the way, include interest on the debt, which is ballooning like crazy, is approaching $1 trillion like overnight, it seems, but it's much faster than anybody anticipated. The full fiscal restraints proposal for that simulation you can read in my footnotes to my testimony. Before I conclude, I just want to say a few words about what you might like to hear the opposition will say about COS when you hear opposition testimony. You're likely to hear a word salad of historical dates, quotes from founding fathers, the Federalist Papers, and even a truncated quote that is shamelessly taken out of context from the late Supreme Court Justice Antonin Scalia. There's nothing in the opponent's arguments that hasn't already been debunked over the years by recognized constitutional scholars who have research that's well documented and peer reviewed. Yet they keep repeating these debunked arguments, hoping that repetition will sway some of you state legislators. I urge you to have a healthy level of skepticism when you hear the opponent's arguments and you hear arguments based on fear. We American citizens are not descended from fearful people. Thank you very much. Please support SJR 3.
Mr. Scott, thank you for your testimony. Are there any questions for this witness? All right, seeing none, thank you for being here today. I'd like to call up Catherine Clark, and Catherine Clark will be followed by Ed Mulholland. Welcome to committee. You proceed whenever you're ready.
Chair Rogner, Vice Chair Gavarone, Ranking Member Blackshear, and members of the committee. My name is Catherine Clark. I'm from Bowling Green, Ohio, Senate District 2. Our system for electing members of Congress was intended by our founders to operate as a free market system, like a free market system. Legislators who serve the people well could be reelected, and those who serve poorly would be voted out. The founders never envisioned career legislators. As proof, throughout the 1800s, the norm was for members of Congress to serve just 1 or 2 terms. From 1850 to 1898, half of Congress was replaced every election cycle. Today, 9 out of 10 members of Congress who run for re-election win. This might be reasonable if Congress were 90% favorable with the American people. However, according to the February 2025 Gallup poll, the approval rating is only 29%. That is markedly high. Why can't the American people get these highly unpopular members of Congress replaced? The answer is that incumbents have unfair advantages. Incumbents enjoy at least a 4-to-1 fundraising advantage. Incumbents can leverage political patronage. Incumbents usually have better established campaign infrastructures. And the ability to hold official events or town hall meetings favors incumbents. Simply said, the deck is stacked in favor of incumbents. It is a wonder that Congress was able to reach this stunning 29% approval rating, having been able to send home only 3.4% of its members. The problems that have plagued our country for decades, crippling problems like our national debt, immigration policy, unfunded entitlement programs, never seem to get fixed, partly because the participants who have either created them or have failed to correct them continue to stay in office. As the 22nd Amendment to the Constitution places term limits on the president, it is now time for an amendment that places term limits on the U.S. Congress or federal agencies, agency heads, or even federal officials, other federal officials. Term limits would see new perspectives, fresh ideas, and novel solutions to our nation's aging, perpetual problems. Legislators would return home to live under the laws they passed or the problems they failed to solve. Term limits would incentivize members of Congress to not consider paparazzi opinions, but would be empowered to make the tough decisions that create lasting solutions. The concern that term limits on Congress could backfire if the period of service is too short was reflected in the results of an Article 5 convention simulation that occurred in August of 2023 with actual state legislators. In that simulation, the term limits proposed were 18 years for the House, 18 years for the Senate, with a maximum combined service set at 24 years. 24 years seems long enough, should a similar amendment proposal come out of an actual convention. In closing, placing term limits on Congress through an amendment to the Constitution would turn what are now career legislators into citizen legislators. I, along with 117,000 other Ohio petition signers, ask you to support passage of SJR 3. Thank you.
All right, thank you for your testimony. Are there any questions? I have one. So in this mock convention,
Yes.
you said they came out with 24 years regarding the term limits. What
Yes.
came out of that with respect to fiscal restraint?
I would have to defer because I do not have that information in front of me right now. I know that there were some, a lot. I believe one of them that in my mind would be quite helpful was I believe there was a line item veto.
It's in my footnotes in my testimony, Chair.
Okay,
Oh.
we will refer to the footnotes of the prior witness's testimony. All right, very good. Thank you so much. The next witness I'd like to call up is Ed Mulholland, followed by Roger Gibb. Welcome to committee.
Chair Rogner, Vice Chair Gavarone, Ranking Member Blackshear, members of the committee. My name's Ed Mulholland. I'm from Zanesville, Ohio, Senate District 31. The Declaration of Independence was an announcement to the world that the colonists could and would manage their own affairs. It was a statement establishing the right of individual liberty and local sovereignty. The Constitution followed, securing the liberty of the people by granting the federal government only 27 enumerated powers. James Madison, an author of the Constitution and fourth President of the United States, said it this way, quote, "The powers delegated by the proposed Constitution to the federal government are few and defined. Those which are to remain in state governments are numerous and indefinite." This division of power is called federalism, and it's critically important. As the power of the federal government expands, so expands the necessary regulation and control which steals the very liberties government is supposed to protect. Prior to the New Deal era, local economic activities such as labor, manufacturing, agriculture, and mining were widely understood to be under the purview of state governments. They were not considered part of interstate commerce. Then several Supreme Court decisions reinterpreted the Commerce Clause, enlarging the federal government's lawmaking authority at the expense of state sovereignty. With its newly expanded authority, government grew so much Congress was forced to defer a great deal of authority to newly created agencies, and today, the number of regulations created by federal agencies staffed by unelected bureaucrats dwarfs the number of actual statutes passed by our elected representatives. This reinterpretation of the Commerce Clause can be addressed with an amendment to the Constitution. Doing so will keep power in the states where it belongs and where our country's founders intended it to be. Reinterpretation of the General Welfare Clause has also contributed to the death of federalism. Originally, the General Welfare Clause was interpreted to mean that Congress could only spend money in service of its 27 enumerated powers. It could not spend money for activities on which states could spend money. For example, states have the authority to spend money on education, welfare, medical, and retirement programs. Accordingly, Congress could not spend money on those activities. Then, thanks to United States v. Butler in 1936, the floodgates were opened and Congress is permitted to spend money on essentially anything it wants. This reinterpretation of the General Welfare Clause can also be addressed with an amendment to the Constitution. Without action by the states to constrain federal overreach, we're on a slippery slope toward the concentration of absolute power at the federal level. Concentrated power that inevitably leads to tyranny and the loss of individual liberty. To preserve state sovereignty and the liberties of the people, we must restore federalism. SJR 3 calls for a convention to give states the opportunity to at least discuss this important issue. I urge you to support SJR 3.
Thank you, Mr. Mulholland, for your testimony today. Are there any questions for this witness? All right, seeing none, thank you. Our next witness is Roger Gibb, who will be followed by John Laws and then Diane Tellis. Welcome to committee, Mr. Gibb.
Thank you. Chair Rogner, Vice Chair Gavarone, and Ranking Member Blackshear, and members of the committee. My name is Roger Gibb. I'm from Mason, Warren County, Ohio Senate District 7. My remarks today will refute one of the false claims that is commonly repeated by those in opposition to Convention of States, namely that the Constitutional Convention of 1787 was a runaway convention. More specifically, the claim is that Congress called the Convention of 1787 for the sole and express purpose of revising the Articles of Confederation. However, the convention departed from the mission that Congress had given it. The convention did not simply draft amendments to the Articles of Confederation. Instead, it proposed an entirely new constitution to replace the Articles of Confederation. Now, you might wonder why this claim is relevant to our discussion on whether Ohio should request an Article 5 convention through SJR 3. It's germane because our opposition contends that if the Convention of 1787 was runaway, then it's likely that an Article 5 convention could also go off the rails. However, if it's false, then the runaway Article 5 convention claim has no precedent in American history and therefore no legs to stand on. In 2017, Michael Ferris published an 86-page article in the Journal of Law and Public Policy, wherein he refuted using original source documents the claim that the Convention of 1787 was runaway. Robert Nadelson, the nation's preeminent scholar on the Article 5 convention process, also published on this topic in the Tennessee Law Review in 2010, and he came to the same conclusion. Their key points that refute the claim that the Convention of 1787 was runaway are as follows. Point number one, Virginia called the Convention of 1787 in the fall of 1786, not Congress, as our opposition asserts. The Virginia legislature instructed their delegates to join with delegates of the other states to devise and discuss, quote, all such alterations and further provisions as may be necessary to render the federal constitution adequate to the exigencies of the Union. In 1786, the term federal constitution was understood to mean the federal political system. And so in modern language, Virginia instructed its delegates to find a solution to the country's federal political problems. Now, importantly, Virginia did not instruct her delegates to only propose amendments to the Articles of Confederation or to not draft a new constitution. So point number two, Congress did not call the Convention of 1787. It couldn't because it didn't have the authority to do so under the Articles of Confederation. Congress also did not have the authority to limit the scope of conventions called by the states. Point number 3, on February the 21st, 1787, after 7 states had committed to attend the Convention of 1787, Congress endorsed the convention and issued its opinion that it should be held, quote, for the sole and express purpose of amending the Articles of Confederation, close quote. Now, Congress explicitly said that this was only its opinion, i.e. not a directive, and there's no evidence that Congress transmitted a letter to the executive officers in any state to do anything. Point number 4, 12 of the 13 states attended the Convention of 1787. 10 of those 12 states followed Virginia's lead and gave their delegates broad power to find a solution to the federal political problem that the country was facing. They did not instruct their delegates to not draft a new constitution. However, 2 states, New York and Massachusetts, did instruct their delegates to only propose amendments to the Articles of Confederation. And finally, point number 5, delegates from the 12 states followed their respective instructions pertaining to what they were and were not allowed to do at the convention. The 10 states that were given broad authority from their legislatures, those are the states that drafted our Constitution. And so in closing, I'd like to share a quotation from Michael Ferris's article in the Harvard Law and Public Policy. When we raise our hands to swear allegiance to the Constitution and promise to defend it against all enemies, foreign or domestic, we can do so with a clear conscience. The Constitutional Convention was called by the states. The delegates obeyed the instructions from their respective legislatures as to the scope of their authority. The Constitution of the United States was validly and legally adopted. So I urge you to support SJR 4, and I thank you for our service to Ohio.
All right. Mr. Gibb, thank you for your testimony. Thank you for addressing the concerns regarding the runaway convention. So, any questions? No? All right, seeing none, thank you. Next, I'd like to call up John Laws, followed by Diane Tellis. Welcome to committee, Mr. Laws. You can begin whenever you're ready.
Thank you. Chairman Roger, Vice Chairman Gaveron, Ranking Member Blackshear, members of the committee, thank you for having us today. My name is John Laws. I live in the small city of South Lebanon, Ohio, Warren County, Senate District 7. My remarks today are intended to dispel the claim that our Article 5 convention could become runaway and have dangerous unintended consequences, such as the loss of the Bill of Rights or the entire Constitution. You will likely hear the word runaway convention claimed many times when you hear opposition testimony. In the case of the Article 5 conventions, there are at least 7 safeguards to ensure the meeting conforms to the founder's intent. I was going to read all 7, but I think we've touched on most of them here today. So I'm going to skip a couple of those. I'm going to go really to number 7. In many states, resolutions requesting an Article 5 convention have explicit limitations on delegates' authority. As proof, Ohio SJR 3 states, this application is made with the express understanding that an amendment that in any way seeks to amend, modify, or repeal any provision of the Bill of Rights shall not be authorized for consideration at any stage. That simple statement sums up much of what has been discussed here today. You, our state legislature, controls the vote in that constitutional convention. You are the ones that select those who will represent us and have that one vote at the constitutional convention. We have had somewhere in the neighborhood of 250 conventions across, for 250 years, at conventions across the colonies, then the country. None of them have gone off the rails. None of them have been runaway. It's really not something any of us would expect to happen, nor could it happen by virtue of the way the bill has been written. So,
all right.
Thank you.
Very good. Thank you for your testimony. Any questions? No? Seeing none, thank you. Our last in-person witness is Diane Tellis. Welcome to committee. You can begin whenever you're ready.
I'm wrapping it up by reading. Chair Rogner, Vice Chair Gavarone, Ranking Member Blackshear, and members of the committee. My name is Diana Tellis, Ohio Senate District 4. I'm a volunteer with Convention of States Action and seek your support of SJR 3. This 2,000-page annotated constitution is the legal authority for the federal government and the court system. This contains the original Constitution, the 27 amendments, plus 230 years of Supreme Court rulings and how those interpretations affect the original meaning of the Constitution. Worried about touching our precious Constitution with a state convention? Every time the Supreme Court rules on matters of constitutionality, this interpreted U.S. Constitution grows bigger. Considering this and the current state of affairs in Washington, we have problems that career politicians in D.C. are not going to fix. So we need to look no further than the nation's bylaws, our U.S. Constitution, and Article 5 is still buried in here. Can you imagine playing a role in the proposal and the adoption of any one of these amendments? Restore the original meaning of the Commerce and General Welfare Clauses, limit federal legislation to single subject, permanently set the Supreme Court to 9 judges. At some point, members of Congress, they'll need to consider legislation to support the efforts of DOJ. But will they? The states can propose an amendment to permanently limit dead weight in the federal bureaucracy. If the next presidential administration is less committed to the effort, the bloated bureaucracy and the spending will return unless you codify a process to address it. SJR 3 is straightforward, 4 pages. It's simply an application to Congress for a state amending convention, no more and no less. Please remain focused on the resolution verbiage without the distraction of a few noisy detractors. No, we are not asking to open up or rewrite the Constitution. Nobody ever says that when Congress proposes amendments, and they do it 50 times a year. We do not seek a constitutional convention for rewriting a new constitution. That's preposterous. We're asking for an opportunity for the states, like Congress, to write amendments. The passage of SJR 3 is far too important to allow its meaning to be overshadowed by our opponents' doomsday language designed to impart fear. Our detractors also resort to ad hominem attacks to discredit the reputations of our leadership, our grassroots, and those of our nation's founders. These attacks are fallacies that exemplify bad reasoning. Our opponents use hyperbolic language such as con to describe the convention that we seek. Such juvenile terminology lacks the validity and the sophistication deserving of a provision found in the Constitution. The denigration also detracts from healthy debate. Trust me when I tell you, if you yourself required legal counsel in the highest court, you would choose our premier, nationally known constitutional attorneys over the advisors of our opponents, who are nothing more than hobbyists. The Constitutional Convention of 1787 did not run away. Our founders acted in accordance with instructions from their respective states. The president of the Constitutional Convention was George Washington, the most trusted, honest leader of the age. Our opponents fail to mention that our founders unanimously adopted the state amending portion of Article 5, and that when ratified, amendments can become part of this Constitution, not a new one. The state amending process operates within the framework of the Constitution. We can use the Constitution to save the Constitution, but it contains no provision for destroying itself. Please consider the U.S. Congress is right now a permanent Article 5 convention. Congress can propose amendments on any subject any day of the week. It's hard to imagine the states being more irresponsible than Congress. Yet, there is no running away
or dangerous near miss with crazy amendments coming out of Congress. Why not? Congress is constrained, as are the states, by the political realities of ratification. 38 states must pass any proposed amendment. Since 1789, there have been nearly 12,000 proposed amendments to the Constitution. Like I said, that's about 50 a year. Of these, only 33 have been sent to the states and 27 ratified, the ones supported by the citizens. There were people who feared the founders' Declaration of Independence from Britain. The founders bravely forged ahead anyway. There were people who opposed the abolition of slavery. Lincoln had the courage to do it anyway. An amending convention of states is a safety feature packed into our Constitution by our founders for this very moment in history. The commitment you made to uphold the Constitution includes an Article 5 convention for proposing amendments. So long as Congress refuses to act, it is the duty of state legislatures to utilize this tool and not deny it. Thank you for your time. If you have any questions.
Thank you for your testimony. Are there any questions for this witness? Seeing none, thank you for being here. I'd like to direct the committee's attention to the iPad where you'll find additional 4 pieces of proponent testimony. Is there any further discussion on this legislation? All right, hearing none, this will conclude the second hearing of Senate Joint Resolution 3. And the chair does look forward to additional hearings on this legislation. Again, thank you all for being here today. Is there any additional business to be brought before committee? Seeing none, we are adjourned.
Wow, Rita, what a great hearing. Our viewers, they've been watching a hearing in the Ohio Senate Committee on General Government in consideration of our Convention of States legislation referred to as SJR 3. Rita, let's do a quick recap there because there's a lot in that hearing. One, Michelle Reynolds, she introduced the Article 5 resolution and the 34 Ready legislation. Rick Santorum, our senior advisor to COS, he gave expert testimony. Non-paid members of the COS Ohio team then expressed their support. Today, there was no vote taken. They do a lot of hearings in Ohio, as you mentioned earlier in the program, and there still needs to be at least one, it looks like, opponent testimony. What was your initial reaction to that hearing, Rita?
Well, Andrew, first I want to say that Chair Rogner runs a tight ship in that committee. It was started on time. It was efficient. As you mentioned, they heard proponent testimony today on SJR 3, our Ohio Convention of States application, and they also heard both the sponsor introduction and proponent testimony on SB 112, which is the 34 Ready legislation there in Ohio. It was organized. Our grassroots volunteers did an amazing job. Of course, we heard from Senator Rick Santorum first. He knocked it out of the park once again. Andrew, I love how he pointed out that the topics of the applications for convention matter. He pointed out that that's why we've never had an Article 5 convention yet, because even though over 400 applications for a convention have been passed by the states, there have never been 34 that agreed on the same topic for amendment proposals. That's why we haven't had a convention yet. And then he went on and pointed out that logically then it makes no sense for anyone to say that the topics matter for purposes of aggregation or counting to get to 34, but then they get to convention, they can just throw the topics out the window and propose amendments on anything they want. That doesn't make sense. That doesn't hold any logical water. So that was great. I thought that was an excellent point he made. And then our grassroots volunteers, they were organized. We have tons of grassroots in Ohio, so they could have flooded that hearing room with testimony, but they wisely didn't. They respected the time of the committee members. And we had, I think it was a total of 6 grassroots volunteers testify in person. And they divided up the different issues that needed to be addressed in testimony. We heard each of the 3 subject matters addressed. Someone talked about the need for amendments on fiscal restraints, the need for amendments on term limits, the need for amendments to curb federal overreach. And then we had 2 different pieces of testimony debunking the runaway myth, both the historical runaway myth and the myth that there will be a runaway in the future. And then we had our very excellent Diana Tellis wrap up the testimony and kind of tie it all together with a bow. They just did a great job. Our state director, Bill Scott, leads an amazing team out there, and I was super proud of them.
You got to love Diana Tellis holding up that annotated Constitution. I mean, it looked like she was about to tip over. It's so big. I mean, what's it like 3,000, 4,000 pages somewhere in there? I
It's
love
thousands. Yeah.
I love seeing props like that. It gives you a visualization of the Constitution that our legislators in Washington, D.C. actually follow, not the Constitution that we know and love, the little pocket Constitution that Senator Santorum usually takes out of his coat pocket and shows everyone. Rita, I can't believe that Senator Santorum did better than his last performance. Every time I see him, I'm like, okay, there's no way he's gonna top the bar from last time, but he does every single time. And man, it's a riveting testimony from him each time. And I love Diana Tellis anchoring as well. I mean, it was just incredible.
Yeah, I love their organization and their strategy. And you're right, Rick Santorum is a national treasure. We are so blessed to have him. So looking ahead, Andrew, for Ohio, the next step in this process will be the opponent's hearing. That one's going to be painful to witness, but we're not going to back down from it. Lord willing, we will be here again to bring that to you via COS Live, and it should be interesting. I think we're going to have a lot to say about that one, Andrew. So hope our viewers will just stay tuned and keep watching our channel, and we'll let you know when that is coming up. And again, want to remind everyone we have a big, important happening tomorrow, and that is the Idaho House floor debate and vote on our COS application. We think that's going to happen sometime between 1 p.m. and 2 p.m. Eastern time tomorrow. So again, stay tuned and we'll keep you posted.
Well, Rita, I think that's it for us today. I'm not necessarily looking forward to opponent testimony, but I think we can manage it, like you said. Really looking forward to tomorrow and what goes on in Idaho. Again, tune in tomorrow, conventionofstates.com/COS Live. Until then, we have a country to save, so it's time for us to get back to work. See you tomorrow.